it is coming from outside the country this time.
Yeah.
For $10 billion.
Yeah.
Like, the entire state of Texas could sue Mexico for Tex-Mex food giving us all diabetes. We are the Armed Attorneys. Today we are talking about the Supreme Court's decision to hear a case in which Mexico has sued Smith and Wesson. Stick around, we're going to talk about why Mexico is suing the gun manufacturer, what we think the Supreme Court's going to do with this thing, and finally, what does George W. Bush have to do with it all? But before we get started, show your support for the Second Amendment by hitting the like button.
And so the case we're talking about is Estados Unidos Mexicanos. This is case number 23-1141. If you want to check it out, this is Smith and Wesson appealing the First Circuit Court of Appeals. Now, what's going on here? Well, we have the country of Mexico suing a gun manufacturer here in the United States saying, hey, a bunch of your guns are showing up at crime scenes here in Mexico. Kind of strange, the crimes Mexico pays attention to. But we see this as kind of a concerted effort against the firearms makers, dragging them into litigation, running folks out of business, think Remington. And all right, we have this appeals court saying, hey, this can proceed, overturning a lower court's decision. Now we're here up in the Supreme Court. And what's going on?
Oh boy. So we have the PLCAA, which is really the basis of this litigation, and I love it. I love it so much. And every time something comes up the PLCAA, I'm like, Richard, let's make a video on it. And he's like, no one watches those videos about the PLCAA, Emily, but I love it so much. So we have the Protection of Lawful Commerce in Arms Act, which is in question here because Mexico has sued Smith & Wesson not because the product malfunctioned, not for any reason other than your firearm, which you produce, which works as intended, is being used by our cartels to commit crime in our country. And we have a law about that, the PLCAA, which tells us that unless the gun manufacturer has violated some state or federal law in the marketing of its product, you don't get to sue them for selling a good product that works as intended.
Yeah, and so the exceptions to the PLCAA all fall under, think manufacturer's defects, think breach of contract between the manufacturer and somebody they're contracting with. So, I mean, there's exceptions to it so that everybody's still following good business practices. But the Congress's intent, and this was signed back in 2005, that's how George Bush got involved. The idea behind this was we want to stop frivolous litigation for firearms manufacturers. It'd be the equivalent of suing Ford Motor Company for a drunk driver crashing a car. We don't want to run these folks out of business because we have these third parties misusing the product. And so we see these protections in manufacturing kind of sprinkled all over the place. Firearms manufacturers, no exception here now, they have this protection. But it doesn't seem to be stemming the flow of lawfare.
No, and it's because of one Connecticut court opening the doors here and saying, if you market it like it's dangerous, and whatever that means, then you have broken the marketing laws and you have opened yourself up to suit. And this is exactly why George W. Bush signed this law, why Congress passed it in the first place, is because we had a ton of lawsuits like this before the PLCAA was enacted. We had firearm manufacturers and sellers sued nonstop by anti-gun groups, even knowing they were going to lose under nuisance laws. Why did they do that if they knew they were going to lose? Because that was the whole point, was just to gin up the lawsuits and cost a bunch of money. And I will say, so we have an amicus brief that we reviewed that was very, very good. It was Firearm Policies Coalition's amicus brief. I am not friends with the attorneys who filed it, but I'd like to be, because they used the word insidious 3 times in like the first paragraph, and I love that.
Yeah.
I love that. But I'm actually going to read from what because this is, I think, I'm just going to a little quote, because I have a work crush on whoever it was who wrote this. So here we go.
Buckle up, Buckaroo.
Buckle up. And so this is why we don't allow these lawsuits, and why our lawmakers circa 2004 knew that they had to pass such a law. Even if the radical anti-Second Amendment activists' dream scenario behind the tsunami of lawsuits, imposition of draconian gun control policies from the bench, fails to materialize, sidebar, which they know that it will not materialize. However, the litigation will already have had one of its intended effects. It will have imposed an immense financial toll on America's firearms industry, driving many manufacturers out of business and consequently diminishing Americans' access to firearms. Again, with lawfare of this kind, forcing the disfavored industry to defend against the litigation is the main point of the litigation. That's what this is about. That's why we don't allow this. And that, I hope, is why the Supreme Court has agreed to hear it. Because if we keep letting this happen, we're going to drive the firearm manufacturers out of business.
Yeah, I mean, lawsuits are extremely expensive. And there's nobody sitting at the courthouse saying, this is a good lawsuit, this is a bad lawsuit. I mean, just the act of hiring an attorney to respond to a lawsuit, even go through the initial motions of, hey, this thing's frivolous and it needs to get dismissed, that is all very, very expensive. And so, the gun grabbers view this as a legitimate tactic. Hey, run these folks out of business. I can't think of any groups that have been subject to more lawfare than maybe the conservative right in recent years. And not saying that all these gun manufacturers are conservatives or they're right-wing, but we see that this is viewed as a legitimate tactic to try to destroy their enemies.
Absolutely it is. And it just is, when it happens within the United States from the anti-gun left, from the groups that are funded by, big political anti-gun money, it's one thing. It is coming from outside the country this time.
Yeah.
For $10 billion.
Yeah.
Like, the entire state of Texas could sue Mexico for Tex-Mex food giving us all diabetes. It's that stupid. It is.
We won't because we love them too much.
I mean, I know because I love queso. But it boggles my mind that the First Circuit would say, you know what? Let's revive this lawsuit. It boggles my mind this would even make it to the Supreme Court.
And so what can we expect from the Supreme Court? Well, I mean, I'll say it's a good sign that this is getting granted cert on the first day of the new term. So, I mean, that's a positive sign. That means it is definitely on their radar. What kind of things can we expect from the Supreme Court? Well, obviously they have to have briefing on it. They have to have oral arguments. And then ultimately, do they render a decision? Or does this get thrown into a category of cases and just completely, hey, we didn't have time to get to this, and it goes away? I don't think that will happen. I bet we get a test from the Supreme Court when evaluating, if the PLCAA is raised as a defense early in the case. I bet we get a framework for lower courts to apply.
I agree. I think that we get a decision on this case. I think we get a darn good one. And this is one where, most of the time, because we're busy, most of the time I'm not sitting there listening to Supreme Court oral arguments live. I'm gonna listen to this one live. I love guns. I love the PLCAA. I am hot to trot on this one.
All right. And then, we get our test. Maybe these lawsuits go away. The funding from these anti-gun groups doesn't go away.
It does not.
And so what I would like to hear from folks is, all right, let's say this mole gets whacked, right? We no longer have the money flowing into these frivolous lawsuits to bring down gun manufacturers. Where are these resources getting diverted?
I'm sorry, I can't move past the word whack.
Whacked?
Whacked. Yes, no, it is just, we just take our triad. And this attack is outside the triad, right? The normal triad being what can you possess, who can possess, and where you can possess. This is really outside of that even. So I think if we shut down this avenue, which is what I do think will happen here in some way, shape, or form, we just go back to the triad. They just keep, there's no shortage of Second Amendment attacks that could be well funded.
Yeah. But, this is an important case. It's on the radar now. Now you all know about it. Go check out these amicus brief from the Firearms Policy Coalition. Great job, guys. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, please question and comment for us below. Until next time, we're the Arms Attorneys.